Mr. Hartel. We're here today for a probation violation hearing. Is that what we're still doing today, Mr. Hartel?
No, Your Honor, I do believe we've reached a resolution with the people.
All right. Why don't you go ahead and tell me what that is, but wait till I give you the go sign. I need to find the counts. Ooh, something's telling me it's a no contest. All right. Go ahead, Mr. Hartel.
Yes, Your Honor, my client would admit to all the violations except the new criminal activity allegation. That part would need to be a no contest. He does have a pending case with that same factual basis in district court. We also have an understanding with the people in the probation department that they would recommend an only 6-month sentence, if I understand them correctly. It's not a killer group, just a recommendation.
All right, Ms. Dahl, is that correct?
Is correct, Your Honor, and I did present to the court People's Exhibit 1 that should state the basis of the factual basis for count 3 of probation violation.
Got it. Mr. Petrie, is that how you wish to resolve today's file?
Yes, Your Honor.
To the best that you can, please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. Mr. Petrie, again, you are charged on a request and warrant for probation violation with 4 counts. Count 1 is that you failed to report as directed by your field agent to meet with your agent on March 27th of this year. Count 2 is that on or about March 14th, you moved from the New Hope shelter without permission or informing your probation agent. Count 3 is allegedly that you committed a retail fraud out at Walmart on March 18th. And count 4 is that on or about May 7th of this year, you tested positive for methamphetamine. I'm told that you're going to plead guilty to 3 and no contest. Wait, hold on. You're going to plead guilty to count 1, 2, and 4, and then no contest to count 3 based upon the fact that you're pending charges in the district court. Is that what you thought you were doing?
Yes, Your Honor.
Now, entering this plea, you're going to be given up the right to have a contested hearing and make the prosecutor prove the allegations by a preponderance of the evidence. You'll be given up the right to question and cross-examine any witnesses presented against you, as well as the right to present witnesses, evidence, or testimony if you chose to do so. Does that make sense?
Yes, Your Honor.
Now, we've already talked about before that if you're found guilty of these, you'll be resentenced on your original offense, which was use of the controlled substance methamphetamine, which typically is a misdemeanor punishable by up to a year and $1,000. But because it was a second or subsequent drug enhancement, it was increased to a high court misdemeanor punishable by up to 2 years and or $2,000. And all right, now there's a recommendation here that the prosecutor is only going to recommend an additional 180 days to be tacked onto your sentence, but that's not a promise. That's what I'm going to do. Do you understand that?
Yes, Your Honor.
Have there been any other promises, threats, or inducements to get you to plead guilty or no contest that we haven't talked about today?
No, Your Honor.
Now, the no contest plea has the same impact as a guilty plea, but the difference is instead of requiring you to recite a factual basis, I'm going to look at something such as a police report. You understand?
Yes, Your Honor.
All right, that way your statements can't be used against you. All right, as to count 1, 2, and 4, how do you plead? And as to count 3,
No contest.
and I have People's Exhibit number 1 before me. Any objection, Mr. Hartel?
No, thank you.
For the purposes of taking a plea of no contest to count 3, the court accepts People's Exhibit number 1. One moment. Number 1 here is a incident report from the Wexford County Sheriff Department bearing incident report number 83-2600476. Okay, all right. The court takes judicial notice of the terms and conditions of probation that are contained within the court's file. They were signed by me on December 22nd of 2025, and then subsequently acknowledged in writing by the defendant on December 23rd of 2025. Turn to Mr. Petrie, is it true that you failed to report your probation officer after he directed you to back on March 27th of this year? And is it true that you apparently had left, you were staying at the Hope Shelter, or New Hope Shelter, but left on March 14th and didn't tell them where you were?
I don't know if the date's accurate, but that's valid.
Okay, and is it also true that when you were arrested on this, on my initial request and warrant, that you tested positive for methamphetamine because you had ingested or used some methamphetamine? That's a yes?
Yes,
All right, good, thank you. Ms. Dahl, do you believe he's provided a factual basis to support 1, 2, and 4?
Yes, Your Honor.
Mr. Hartel?
Yes, Your Honor.
Ms. Dahl, do you believe the interests of justice do not require the resuscitation of a factual basis for count 3 and that a no contest plea is appropriate?
Yes, Your Honor.
Mr. Hartel?
I agree, Your Honor.
Ms. Dahl, do you believe the exhibit 1 has sufficient evidence to support that count?
Yes, Your Honor.
Mr. Hartel?
Right.
Ms. Dahl, are you aware of any other promises, threats, inducements?
No.
And do you believe I comply with the court rules?
Yes, Your Honor.
And Mr. Hartel?
Agree, Your Honor.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record, in addition to the judicial notice taken of the terms and conditions, satisfy the required elements of proof for counts 1, 2, and 4. Additionally, the court finds that People's Exhibit number 1 provides sufficient proof to support count 3. Therefore, also, I didn't say it, the court also finds the defendant's pleas are made freely, knowingly, and voluntarily. And the interests of justice do not require the recitation of a description of the offense for count 3. Therefore, the defendant is found guilty of all 4 counts. All right, can we proceed to sentencing, Ms. Dahl?
Yes, Your Honor.
Mr. Hartel?
Yes, please, Your Honor.
All right, Mr. Saladay, why don't you go ahead and see what you got?
Your Honor, he was originally placed on probation December 22nd of this last year. At that time, he was sentenced to 90 days jail. He was released the very next day to attend Koski Hall. He did complete that program on January 22nd.
Good.
Sentencing guidelines in this case are 0 to 17 months. Current jail credit. So the recommendation right now is going to be that probation will be continued after 180 days jail, credit for 73 days served, all fines and costs are due.
Dahl?
Your Honor, I concur with that recommendation. The underlying offense and the guidelines, very recent relapse and violation. With how close of a time he had to sentencing, I believe a 6-month sentence would be appropriate in this case.
Thank you. Mr. Hartel?
Yes, Your Honor. I've spoke with my client. I believe he will wish to make a statement in a minute. I've made sure to stress not to mention anything about the part we pled no contest to for obvious reasons.
Yep.
But we're not disputing that he did have an issue with drugs, continues to have an issue with drugs. I believe my office social worker forwarded a letter to both the court, the people.
I got that from
Yes, Your Honor.
ATS.
Yes, Your Honor.
I've got that and I read that and we received it last week.
Yes, we would ask the court to fashion a sentence where it could perhaps adopt the recommendation, but hold it in abeyance, at least largely in abeyance, so that he could have that. I know with talking to him, I perhaps made it more cartoonish, talking about an anvil being over his head, perhaps more Bugs Bunny style there. I know this is very serious, but
I love Bugs Bunny. It's okay if you use the references.
okay, thank you, Your Honor. But I do believe him going back to treatment would help him. I do believe it would help him be better at probation, overall be a better citizen. I know he has a very low bond set in his other file, I believe 510%. If the court could fashion a sentence to allow him to go to treatment with that anvil over his head, I do believe that we could help get him released downstairs as well. Again, he does wish to make a brief statement.
All right. Mr. Petrie?
This all started with like me making a poor choice and I made it 147 days clean before I even did anything. I was going through my stuff and found some stuff, and in my mind, I said, "Who's gonna know?" And my therapist said that you would know. And I I feel extreme remorse for what I've done. I feel dumb, I feel shame, I feel so tiny that, I mean, I let myself down, I let my son down, I let everybody down. I made Mr. Salady's job harder, I made your job harder.
It's okay to make his job hard, that's fine.
I'm just like, I feel a lot of, I feel little. And I let, most of all, I let myself down, and I'm all about self-growth, and if allowed, I'll prove that and go again, but I'm willing to do whatever it takes.
All right. Well, we do need to have the court needs to have a consequence here. And not only involve the use, but also the shoplifting, not staying in contact. Really, that's what they're there for. Mr. Saladay is not a bad guy. You know, he does a good job. He cares for people, and you reach out to him, ask for help. I guarantee you they're gonna give it to you, whatever they have available to them. So, ask for help and assistance instead of forgiveness when it's after the fact, okay? I guarantee every single person here in this courtroom wants to help see you do better, all right? And we will do whatever we can to help get that done for you and your benefit. So the court's going to continue probation. How long did I set it for before? How long was this probation?
24 months.
Yeah,
Other 3.
I can increase it. We're gonna keep probation as previously set by this court. The court reserves all fines and costs. The court sentences the defendant to the 180 days. And how many days does he have credit?
73, Your Honor.
73 days. Now, if for some reason Mr. Saladay is able to get you into a program and it's able to work out, I'm more than willing to pull it and let you go out to that program early, okay? That's all up to somebody else. Most people think that the judges do it. I don't do that. It's not. I'd love to help, but it's not my job. That's what other people do. And I trust that they will do it for me. Any questions, Mr. Petrie?
No, Your Honor.
All right. Madam Clerk is going to give to the probation officer, who's going to hand to you and your counsel 2 copies of one document. You're going to place your initials on the first one. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the other copy. Now, this document tells you that you have the right to appeal the conviction and sentence in this court based upon the original plea, and even the pleas today. Any appeal is done by filing what's called an application for leave to appeal, and not an automatic or a claim of appeal by right. If you choose to file an application for leave to appeal, and you want the court to appoint an attorney to assist you, you complete the bottom half of that document, return to the court within 42 days. Now, I would never dissuade anybody from filing an appeal, but you'll be well out of the jail before anybody ever looks at the case if you ask for one, but that's all up to you. All right, just letting you know. Any questions, Mr. Petrie?
No, Your Honor.
Mr. Hartel, any further?
No, Your Honor.
Ms. Dahl?
No, Your Honor.
And Mr. Saladay?
No, Your Honor.
You're a good guy, right? He tries to be. You heard him. You said it. Thank you.
Thank you.
We're adjourned.
Appreciate it.
Thank you. Your exhibit.
Thank you.
Right. Then there was one. I need to take a brief comfort break, mostly because I'm thirsty. No. Oh, nope, that's it. Thank you. Thank you. So, those who may watch us on live stream, we do not live stream anything that involves young children, so we will be stepping off of YouTube. Please don't